Hi folks, welcome to SQE1 window, and here in chapter 11 of our SQE1 criminal litigation, we are examining professional conduct in criminal litigation, the ethical framework that governs how solicitors must behave. And that's not advisory, and it is compulsory that when you represent clients in criminal proceedings, you need to follow certain guidelines. So professional conduct is not just about following rules, it's about maintaining trust in the justice system. So along with representing your client. The Solicitor Regulation Authority Code of Conduct creates clear boundaries, and understanding these boundaries is essential both for passing the SQE and for practicing competently and ethically. So this chapter examines authority to act, confidentiality, conflict of interest, and the duty not to mislead the court. So the SRA Code of Conduct shapes how solicitors must conduct themselves in criminal litigation. Understanding this framework is fundamental to ethical practice. Criminal litigation involves three key relationships that must be properly managed: the relationship with your client, your relationship with the court, and your relationship with third parties, including co-defendants, witnesses, prosecution, and others. Four core themes run throughout professional conduct in criminal practice: authority, confidence, conflict, and candor. Authority means ensuring you have proper authorization to act on your client's behalf. This is not automatic, you must confirm it. Confidence means maintaining client confidentiality, protecting their information except where law permits or requires disclosure. Conflict means identifying and addressing situations where your duty to one client might conflict with your duty to another, or where your interest conflict with your clients. Candor means being honest with the court. Misleading the court is never acceptable, whether by positive misrepresentation or by omission. A critical distinction exists between law and fact. Your duty to assist the court with law differs from your duty regarding facts. You must correct legal errors, but generally need not reveal facts which may prejudice your client's interest. So in exam, you need to spot the rule, then apply the scenario. Professional conduct question requires identifying which SRA provision applies. So in this slide, we can easily see that you need to help court on law, but you don't need to reveal facts at that point for the court. So, criminal litigation creates unique pressure and challenges that make professional conduct very important. First, it is high pressure environment. Cases move quickly, stakes are high, clients face potential loss of liberty, and decisions are impacting their life, and decisions must often be made under time pressure. So these pressures can tempt corners to be cut, but professional standards remain absolute. Second, clients are often initially inaccessible. They are in police custody, being questioned, or unavailable to communicate freely. This creates practical challenge for confirming instructions. Third parties frequently request information, like family members want updates, co-defendants, lawyers want to share information, courts, they need case management details. Each request must be assessed against confidentiality duties. And fourth, the important conflict risks arise quickly. Co-defendants may initially present aligned defenses that later diverge. What seems like a single representation can rapidly become incompatible interests. Fifth, courts expect candor. Judges and magistrates rely on solicitors to be truthful about procedure, law, and their authority to make representations. Breaching this trust undermines the entire judicial system. So in exam, pressure is not a justification. Time constraints, client demands, or practical difficulties never excuse professional conduct breaches. So standards remain absolute regardless of circumstances, because my friend, this is criminal law. Say, third-party instructions. So part 3.1 of the SRA code governs third-party instructions. Understanding this rule is essential because criminal practice frequently involves third-party making initial contact. The core rule is simple. You breach professional conduct if you act on someone else's instruction without confirming the client actually authorized them to instruct you. This applies when someone other than the client instructs the solicitor, perhaps a family member, calls requesting representation, or perhaps another professional refers the case to you. It also applies when joint clients exist and one purports to instruct on behalf of both. You cannot assume one co-defendant has authority to instruct on behalf of another. As the solicitor, you must be satisfied that proper authority exists before acting. This is not about what's convenient or what third party claim. It's about actual confirmed authorization. If you cannot satisfy yourself that authority exists, you must not act until you have confirmed it. Taking unauthorized instructions breaches the code and potentially creates invalid retainers. So in exam, you need to keep in mind authority first and then act. That's your formula to answer questions right. So before taking any substantive step on client's behalf, confirm you have proper authority to do so. This confirmation is foundational to the solicitor-client relationship. So once again, criminal litigation creates specific scenarios where third parties commonly make initial contact, and understanding these scenarios help you apply part 3.1 properly. First, the client is often in police custody initially. They are detained at a police station, being questioned or held pending court appearance. They physically cannot contact you themselves. Second, call centers might contact solicitors first. Many firms use call centers to get initial inquiries, and these centers might make first contact on behalf of detained client. Third, friends or relatives frequently make initial contact. A partner, parent, or friend learns of the arrest and contacts solicitor seeking representation. However, there is a critical limitation that we often miss. Third-party contact cannot replace taking direct instructions. The third party can alert you to the situation, but they cannot authorize the retainer or give substantive instructions. The proper treatment is viewing third-party contact as preliminary only. It alerts you to a potential new client and provides initial information, but you must still confirm authority directly with the client. So in exam, you should just keep in mind custody explains third-party contact, not authority. The fact that clients are in custody explains why third parties call, but it does not authorize those third parties to instruct on the client's behalf. Direct confirmation remains essential. That's what you need to keep in mind. So, when third party contact occurs, specific steps must be followed to ensure compliance with part 3.1. So, step 1, check that the client actually wishes to instruct you. Just because someone contacted you does not mean the client wants your representation. Confirm the client's wishes directly. Step 2, take instructions directly from the client. This means speaking with them, explaining your role, confirming what they want you to do, and establishing the scope of your retainer. Step 3, confirm authority as soon as reasonably possible. If immediate contact is impossible due to custody or other circumstances, confirm at the earliest opportunity. Step 4, do not rely solely on the third party's assertion. Even if a family member insists the client wants you to act, verify this directly. Step 5, record the confirmation and scope of retainer in writing. Document when and how you confirmed authority, what instructions you received, and what you are authorized to do. These steps protect both you and your client by ensuring the relationship begins properly with clear authority and mutual understanding. In exam, you should keep in mind direct client confirmation is essential, no matter how trustworthy the third party seems or how urgent the situation. Direct confirmation with the client is required. So that's what you need to keep in mind as professional ethic. So the next thing is confidentiality. Part 6.3 of SRA Code addresses confidentiality, one of the most fundamental duties owed to client. The core duty is keeping client affairs confidential. Everything you learn about your client's case, circumstances, or personal matters must be kept confidential. Two exceptions exist. First, disclosure is permitted when law permits or requires it. Certain statutes or regulations might authorize or mandate disclosure despite confidentiality. Second, disclosure is permitted when the client consents. If the client agrees to information being shared, you may disclose it. These rules apply to all case details and updates. Whether it's the charge, the plea, court date, evidence, or personal information, all are confidential. The default position must be say nothing unless you have clear consent or legal authority. Decline all requests for information. In exam, you should keep in mind no consent, no disclosure. This simple rule captures the essence of Part 6.3. Without client consent or legal authorization, maintain absolute confidentiality, regardless of who requests information or how reasonable this request seems. So, criminal litigation generates frequent confidentiality challenges as various parties request information about your client case. Family and friends commonly request updates. Parents want to know what's happening with their child's case. Partner wants information about court dates and outcomes. These requests seem reasonable and are often well-intentioned, but they still require client consent. Co-defendant solicitor may seek to share information. When multiple defendants are charged together, their solicitor might want to coordinate defenses or share disclosure. However, sharing your client's information once again requires consent. Prosecution or court might request case details. While some court-directed disclosures are required by law, many routine requests, such as for case management purposes, still require client consent. The fact that a request serves case management or seems legitimate does not automatically authorize disclosure. After each request must be assessed against confidentiality, rules and obligations. So disclosure can harm client in unexpected ways. Information shared might be used against them, might reveal defense strategies, or might compromise negotiations. So error on the side of maintaining confidentiality can be serious. So in exam, keep in mind, legitimate request does not equal permission. The fact that someone has a seemingly good reason for requesting information does not authorize you to disclose without proper consent or legal basis. That's what you should keep in mind. So, confidentiality permitted disclosures. Only specific circumstances allow disclosure of confidential client information. Let's identify them clearly. First, the client gives express consent to disclosure. This consent should ideally be in writing or clearly documented. The client must understand what information will be disclosed to whom and for what purpose. Second, disclosure is required or permitted by law. Statutory obligations, court orders, or regulatory requirements might mandate or authorize disclosure despite confidentiality. Third, a court order specifically compels disclosure. When courts properly order disclosure, you must comply even without client consent. Otherwise, refuse disclosure requests politely but firmly. Explain that you cannot provide information without client's consent. So, suggest that the requesting party approaches the client directly if appropriate. Obtain written consent where feasible. Email or signed authority provides clear documentation that consent was given. In exam, keep in mind, identify the lawful gateway to disclose. When facing disclosure request, identify which exception applies, consent or legal authority. Without either, maintain confidentiality. So this was confidentiality, and let's talk about conflict of interest. Part 6.1 of SRA Code addresses conflict of interest, situations where your duty to one client conflicts with your duty to another, or where your interest conflicts with your client's interest. The rule is clear. Do not act when or where there is conflict of interest or significant risk of such conflict arising. Notice that you need not wait for actual conflict. Significant risk is enough to prohibit acting. Assessment must be continuous, not just at the start. You cannot simply check for conflict when first instructed and assume everything remains fine. As cases develop, conflict risk change, requiring ongoing evaluation. So criminal co-defendants represent particularly high conflict risk. Their interests often diverge as cases progress, making shared representation problematic. The conflict rule protects two fundamental values: your independence and client trust. Client must know you are acting in their interest alone, and you must be free to provide undivided loyalty. So, continuous assessment means regularly reviewing whether conflict have emerged or risk increased. What seemed manageable initially might become untenable as evidence emerges or defenses develop. So in exam, keep in mind, significant risk is enough to stop acting. You need not wait for conflict to materialize. If there is significant risk of future conflict, you cannot act. This precautionary approach protects all parties. So, joint defendant conflict representing co-defendant in criminal proceeding creates inherent conflict risk requiring careful analysis. The initial risk is the jointly accused defendant often have conflicting interest from the start. Even if they initially claim aligned defenses, underlying tension usually exists. Blame shifting is common. As cases progress and pressure increases, co-defendants frequently shift blames towards each other. One might claim to be the minor player, the reluctant participant, or one misled by other. So accounts may diverge as evidence emerges. So initial stories that seemed consistent fall apart when confronted with disclosure. So co-defendants start giving different versions of events, claiming different levels of involvement, or disputing what others said or did. When accounts diverge, so shared representation become unsafe. You cannot properly represent client A's position that client B was the primary actor, while also representing client B. The conflict is you cannot reconcile this conflict. So the required action is declining representation for one client and recommending separate legal advice. So some firms adopt policies of never representing co-defendants precisely because conflicts are so likely. So in exam, co-defendants rarely safe for one firm. The presumption should be that co-defendants require separate representation every time. So conflicts don't always exist at the start. They frequently emerge during proceedings as evidence develops and defenses crystallize. First, recognize that conflict may appear later. Initial alignment might prove illusionary. So, evidence you did not initially know about might reveal conflicting interest. Second, if you are acting for both co-defendants, when conflict emerges, you must withdraw from representing both. You cannot choose to continue representing one. This would create an unfair advantage and breach duty to the other. So, third, you should just stop acting and it should be complete. Withdraw entirely from representing either defendant. This is the only way to avoid the appearance of favoritism and protect both clients' interest. Fourth, withdraw favors neither client over the other. So if you continue representing one, the client gains the advantage of your knowledge about the case of other at that point, and the other suffers disadvantage. Fifth, protect confidential information and files carefully during withdrawal. Information learned from one client must not benefit or prejudice the other. In exam, you should keep in mind late conflict means full withdrawal from both of the clients. That's what you need to keep in mind. So, duty to the court, it's very, very important, and I believe I will try to make sense of it. Part 1.4 of the SRA code establishes the fundamental duty not to mislead clients or the court. The duty is absolute and overrides client wishes when necessary. Misleading can occur in three ways. First, by positive act, actively making false statements or representations to the court. Second, by omissions, failing to correct misunderstanding or allowing the court to proceed an incorrect assumption when you know the truth. Third, by complicity, being complicit in client or third-party conduct that misleads the court. You cannot turn a blind eye to misconduct. This duty can override client wishes. If maintaining confidentiality would require misleading the court, the duty not to mislead will take precedence. This creates a difficult situation requiring careful navigation. The duty upholds the administration of justice. Courts rely on solicitors or advocates' honesty. If solicitor misleads court, the entire system breaks down. Trust is fundamental to justice. In exam, keep in mind, never mislead, even by silence. Active lies are obviously prohibited. By allowing the court to be misled through your silence is equally problematic. That's what you need to keep in mind once you are sitting in SQE. So, client admits guilt but pleads not guilty. This scenario appears frequently in exam and practice, requiring careful understanding of what you can and cannot do. First, you must advise your client on the guilty plea options and the credit they would receive for entering it. Explain the sentence discount, the certainty it provides, and the advantages of resolving the case. However, the plea decision remains with the client alone. You advise, but they decide. If they insist on pleading not guilty despite admitting guilt to you, you cannot override that decision. You cannot push them, force them. You may continue representing them, and you may put the prosecution to that proof. This means requiring the prosecution to prove their case, testing whether they have admissible evidence, and ensuring proper procedure. You may test and challenge the prosecution evidence, cross-examine, and you can put legal arguments about admissibility and procedural challenges, and it is all good. You are good to go for that. However, you should keep in mind you cannot run a positive defense you know to be false. You cannot call the defendant to testify to a fabricated alibi. You cannot present witness evidence you know is untrue. You cannot advance factual assertions you know are false. The line is clear. Testing the prosecution's case is proper. Actively advancing known falsehood is prohibited. So in exam, proof testing allowed. False defense forbidden in all its genres. Misleading the court. Practical scenarios. Real-world situation require balancing the duty to the court against confidentiality obligation. So let's examine specific scenarios. Scenario 1. Client provides false personal details to court, wrong name, address, or date of birth. If they persist despite your advice, you must withdraw. Allowing known falsehood to stand makes you complicit. So just withdraw from that. Scenario 2. The court's list of previous conviction is inaccurate. Perhaps it omits convictions or includes some wrong entries. You must not confirm or adopt inaccurate information. Don't affirm don't affirm the incorrect record at that point. So, scenario 3, correcting the record requires client consent because criminal records are confidential. If the record understates convictions, you need consent to reveal additional convictions. Without consent, you face a dilemma. Scenario 4, if consent is refused, you must consider withdrawing. You cannot allow material inaccuracy to mislead the court, but you also cannot breach confidentiality without consent, so withdraw. So, the balancing requires careful judgment. You must manage the tension between the candor and confidentiality, often by seeking client consent or withdraw if consent is refused, and this is frequently tested in SQE. So in exam, you don't need to endorse inaccuracies. Manage the dilemma. Never adopt information you know is false. When confidentiality prevents correction, don't confirm the falsehood. Remain silent or withdraw. I hope you understand it. So very small font, I'm sorry for that, but we had to put a lot of things on this slide. So always start answer by identifying the relevant SRA code provisions. So professional conduct question test whether you know which rule applies. It might test you in this way as well. For third-party instruction, the key is confirming client authority quickly. Don't act on family or friends' instruction without direct client information. For confidentiality, remember the default is maintaining confidence. Only disclose with consent or lawful basis, usually statute, regulation, or court order. For conflict, co-defendants trigger immediate conflict assessment. Presume conflict risk unless clear reasons exist to think otherwise. For late arising conflict, withdraw from representing both clients. You cannot favor one by continuing their representation. For duty to court, avoid misleading by act or omission. Silence that allows misunderstanding is a problematic as active falsehood. For the guilty client pleading, non-guilty scenario, you may test prosecution proof but cannot run defense you know are false. For false details provided to court, withdrawal becomes mandatory. if the client persists despite advice. For inaccurate conviction list, do not confirm inaccuracies. If correction requires confidential information and consent is refused, consider withdrawal. So distinguish legal disputes from factual dispute. You must assist the court with point of law, citing relevant authorities and correcting legal errors. However, you have no duty to reveal facts that prejudice your client unless doing so is necessary to avoid misleading the court. Record all decisions and client consent carefully. Documentation proves compliance with professional duties. Formula for full marks: rule plus risk plus required steps. State which SRA provision apply and how they work, what are the boundaries on your actions and inactions. And one action we would request you, and that is subscribing our channel if you like it, and share it with your friends. Wish you all the best. Ta-da!